Thank you.
Mr. Looney?
Good morning. May it please the Court, William F. Looney, Jr., Charles P. Kindrigan, acting for the petitioner, Matthias Yakah. This case is an appeal from a determination by the Board of Bar Examiners that, I'll hold this up a little, not to recommend that Mr. Yakah be admitted to the Massachusetts Bar without examination, as the motion sought. Involved as well is an earlier request by the petitioner that he be permitted to take the Massachusetts Bar exam as a method of entrance into the bar, and that had been turned down too. It is the petitioner's position that as an attorney who has a satisfactory academic record and is fully qualified for practice in all the courts of Ghana, Africa, a country whose jurisprudence is common law and its laws are consistent with English and with American laws.
How do we know that?
It's admitted.
It is. Do we know the content of what his courses were in law school?
I'm sorry, Your Honor.
We have his transcript, says he took constitutional law and so on and so forth. Do we know what the actual content of those courses were?
No.
No. Can we assume the constitutional law would be the constitutional law of what? England? Ghana? Would clearly not be United States?
I think that it's sort of generally understood that Ghana was at one time owned by England, and it's got a law system that is English in nature and rather like American as well. It's a common law proposition. I'm sorry.
How do we know that?
Well,
on this record?
It's in the record, is it not? Give us a chance to.
I mean, he certainly has distinguished qualifications, but, for example, with his course on, quote, immovable property, which I assume would be real property law in the United States, does that show the same kind of content of real estate law that an American law student
I cannot answer the question, really, that you want me to answer because...
Well, isn't the record deficient in that regard?
Well, I was getting to the point that, to a very large extent, the record is made up of information that he provided at the request of the board. There's a form, and it's about 20 pages long, and he answered all the questions that he was asked. The board did not ask for any information like, for example, write down, tell me what happened in the first case you ever tried, or tell me how many of this you've tried, or how many of that you've tried, or tell me what happens when in a Ugandan court.
But isn't the burden on him to show that his education is equivalent?
Well, I don't think it's up to him to decide what the board wants to do about something, really. I mean, if the board were interested in that kind of information, the board could ask for it, but never did. I mean, the fact is this, and he's not the only one either, I don't think. He did what he was asked to do. It's not a question of a burden of proof, particularly. I think if the board had wanted that information because it intended to use it for some purpose or other, presumably it would have asked for it. But it didn't. And I think if, for example, if they haven't asked enough questions to satisfy, I mean, you folks are the ones who
Perhaps we send it back to the board for more
inquiry
on what...
One way to do it would be to send it back to the board.
Let me ask you,
for a hearing, which has never been held.
Mr. Looney, assuming for a moment that we agree with you on the general common law knowledge, what about his specific knowledge about American jurisprudence?
Well, presumably, this is a matter which would have been taken up in the bar exam, I would think. But again, there was no questions asked of him. I don't think it's fair to have someone who's asking to be admitted to the bar and is given a whole series of questions to fill out, all kinds of information. I don't think
Well, let me ask you this. I know he has an LLM degree from New England Law School.
Correct.
Did he take courses for grades at New England School of Law?
he took-
And were those courses related to our American legal system?
Yes.
That was a softball question.
Can I ask you this?
But I'll just say I don't know.
If he's admitted on motion, he would be able to engage in general practice in Massachusetts, would he
Yes.
not?
Yes.
So let's assume then someone comes in with a fairly intricate conveyancing problem, and he takes it on, and the law that he studied of immovable property in Ghana does not equip him to deal with that problem, and he
Right.
commits malpractice.
Well, I mean, usually things don't work quite that way, Your Honor. I mean, assuming he didn't understand all the ramifications of a transaction, I would expect him to go to the social law library
Well,
and find out about it
I
and
know.
do it, or give it to someone else who knows how to do that kind of stuff.
Has he practiced or been affiliated with any law practice in the United States?
No. He worked for a couple of months for Catholic Charities in a kind of a helper role, but he lives in Worcester, and he wasn't getting paid.
Does
He was
the
just
record,
offering his
does
services,
the
and
record
he just ran
disclose
out of
his
money.
intention on what he would do if he was admitted on motion?
If he were admitted on motion, I believe that he would attempt to start up a
Law practice.
small, general
Because in
practice.
some states, with regard to foreign admissions such as this, they grant, and perhaps maybe in Massachusetts it ought to be considered, maybe it has been considered, Mr. Muldoon can tell us that, but they grant a limited license to practice, limited to certain areas where there's demonstrable competency
Right.
by the foreign lawyer.
As a matter of fact, I think that issue is floating around, whether you can unbundle issues and represent somebody only as something or other. But again, if the board were interested in that information, they could have asked for it. I'm sure he would have told them. But I don't think it's fair to impose on him a burden of trying to figure out what it is he's supposed to tell them when they've already handed him a lengthy list of questions calling for the disclosure of information that they wanted.
Now, they have his transcripts. They have his transcripts from the law schools in Ghana,
Yes,
the names of the courses, the descriptions
Yes.
of the courses?
yes.
No description.
No
Well,
descriptions, or?
No, I know, unless you just assume that the name means something, like constitutional law. I mean, I
Yeah, but
figure
that doesn't tell you
constitutional law
anything.
is constitutional law, you know.
Well, maybe it is, maybe it isn't.
And generally speaking, I think the board has tried not to get involved in comparative grading. You know, how much did you learn in that, how much did you learn from this particular law school as opposed to that particular law school? And then somebody saying, but I slept through the,
Now, I know he's asking to be admitted, but he also asked to sit for the bar exam.
yes, yeah, that's right,
It-
yes, Your Honor.
And if we thought that he should be allowed to sit for the bar exam, would that be acceptable to him?
Yes.
Can you tell me about his attendance at New England School of Law? When did he get that LLM?
The program that he signed up for, is a program that, as I understand it, was developed because of the number of people wanting to take the New York bar. And the New York people will accept that year's worth of work if he passes and allow him to sit in New York, along with everybody else who passed. Now, that is of interest to us only because, in the first place, we haven't really agreed that we would do what New York would do, you see. But at the same time, it does lead to an LLM, And again, that doesn't necessarily answer the whole question, but in trying to determine whether or not this man is at a point in his legal career where he's more or less at an LLB stage, it's important, I think, to remember that New England School of Law isn't going to allow anyone to be in an upper class leading to an LLM unless it's satisfied that he's got a degree or that what amounts to a degree. And I would think if I were on the board, if I were really interested in who's who and what's going on, the fact that he was selected by New England School of Law would be of great interest to me. I mean, I think that that is evidence of his qualifications.
Does the record tell us, did he sit for the New York bar?
Yes, he did twice.
Did he pass?
Not yet.
The fact that
He
he's
missed the
accepted
first
by-
time by 1
The fact
point.
that he's accepted by New England for a master's degree, in what field, what was it in, master's degree?
I don't,
That
excuse me,
occurs-
I don't know
That
the
occurs
name.
quite frequently at NYU, Harvard, other schools, New England. They
Right.
accept foreign law graduates, as they should, for master's degrees.
Well, I
in a
think
notion that they're engaging in kind of international law programs.
the impression that I had was that sometimes it's because the individual wants to become knowledgeable in a specific subject, like the tax program, I think it's at BU.
Right.
On other occasions, and I think this particular situation is one in which the idea is to generally upgrade people who are foreign students who will intend or who intend to practice in Massachusetts.
So we know that he has failed the New York bar exam twice,
We know that he has taken it twice. We know that he's going to take it again.
and we can infer that he did not pass.
He did not pass. He missed by 1 point, and then he missed by a few more than that the next time.
Okay.
And he's taken and passed the multi-state professional
He
responsibility.
has taken and passed that, yes, Your Honor, he has. So, getting back to matters at hand, I guess, the fact is that it is our position that the application of a bright line to determining who can go and who cannot is inconsistent, I think, with Rule 6 and also with Rule 3, because nowhere in the rule does it call for the development of a specific bright line. If you don't get a 75, you flunk type of thing. And it seems to us that not only is that not called for in the statute, but indeed the development of it by the board is really inconsistent with what its role was and what it was told to do by this court. I just think it isn't appropriate and it shouldn't be followed. There should be a process by which it is possible to generally assess how far along an individual is
Do we know what other states...
without doing that.
Do we know what other states are doing in this regard? We do know, for example, I guess...
I'm
that New
sorry,
York-
do-
Do we know what other states are doing?
No, I don't know. Well, I mean, I've
Shouldn't we
heard.
at least have kind of the information of what's going on in other states on this?
Well, I think...
Well,
that
we
the-
know that New York will recognize an LLM and allow a person to sit for a bar.
Yes, we know that, and we know that if New York will do it, that the Second Circuit will do it, I think, wouldn't? And, well, that's how much we know about that. I think, again, I don't know that our client should be responsible for knowing all of those things. I mean, he ought to be able to go in and take a test.
Oh,
I
I don't know
think.
about that. The bar examiners are sort of like gatekeepers to make sure that people, you know, you've got this huge issue of malpractice out there, and innocent people could be dreadfully harmed. I'm not saying necessarily that he would do so. We don't even require malpractice insurance in Massachusetts.
I know, but I don't see, if, it seems to me that instead of having this bright line process, For example, the man in my position, he's already gotten an LLM from New England. He's filled out all kinds of, given all kinds of straight answers to a lot of questions. He answered all the questions that they asked him. I don't think he should be responsible for determining whether a better approach would be to do something else.
Well,
I
maybe
think he, at least, is in a position at the moment where he should be qualified at least to take the exam.
Okay, thank you.
Thank you, Your Honor.
Mr. Muldoon? Oh, sorry.
Ms. Kosky.
May it please the Court, Katie Kosky on
Ms.
behalf of the Board of
Kosky.
Bar Examiners. With me is Robert Muldoon, Jr. To respond to the major point that my brother has made, the burden does lie with the applicant under this Court's rules, this Court's jurisprudence in the Yakah versus the BBE case, and under the BBE's own regulations and guidances provided to applicants.
So what does that require? What does that require? A lawyer educated and licensed in a foreign jurisdiction, what is it that should be apparent to that lawyer that he needs to present to the BBE in order to be properly considered?
The applicant is required to provide the BBE with sufficient information to establish that the education that he received in the foreign jurisdiction is equivalent to that offered in a JD program at an ABA-approved law school.
Do we specify a little more, a list of things that he needs to produce?
To some extent, we do. In a pamphlet entitled Information Relating to Admission of Attorneys in Massachusetts, which is put out by the BBE asks applicants to provide course descriptions, transcripts, an employment and practice history in the foreign jurisdiction. All of these...
Can we pause for a minute? Because it seems to me you informed him that course descriptions should be supplied?
Yes, that is contained.
I mean, I would
in
think that would be
guidelines.
critical, because how can you tell on the face of this record where the courses are named what the content of those courses are? They could be 180 degrees removed from what an American law student would learn in order to practice law in Massachusetts. And that was not supplied in this case, was it?
No, it was not. And the Board would agree with Your Honor that the BBE just did not have sufficient information from the applicant to make any decision but the decision that it made, which was to not recommend that Mr. Yakah be admitted on motion or to be allowed to sit for the bar.
So this long form that Mr. Looney was speaking about, this 20-page form, what information does that gather? This information or something else?
It asks for identification of the institution where he received his degrees, the time frame, the various employment opportunities that he had and the time frame of those opportunities. The information relating to admission put out by the BBE asks for this additional information, such as course description, employment history, from specifically directed towards applicants who are trained at a foreign institution.
Are you saying that the questionnaire does not ask for course descriptions?
The questionnaire does not have on it a line that says, you should attach to this form a course description. This is a
So it's the brochure.
Correct.
Which is the brochure given to each person who's given the questionnaire?
It's made available at the same time, yes.
Made available means it's given to the person who gets the questionnaire?
I can't answer the question about whether it would actually be handed to the
Would a person have to
applicant.
know to ask for the brochure?
That I can't answer that.
So I'm a lawyer from another country. I write the Board of Bar Examiners. Somehow I get the questionnaire.
Mm-hmm.
How do I know there's a brochure?
I believe that when an applicant asks the board, what do I need to do? I'm a foreign trained attorney. What do I need to do to apply? This information would also be provided to that applicant. Yes.
There is a brochure
Correct.
that you can ask for?
It's also available on the BBE's website, and it's listed under foreign applicants. Click on it, and you can open that as well.
For example, here's a question: provide a complete, I emphasize that word, description of your work, including whether it was so on and so on and so on. The answer is full-time pupillage, law clerk. How can you tell from that what the work entailed? Full-time pupillage. I don't know what that means.
Again, the board was left with the same conclusion as Justice Graney.
Reason for leaving, end of pupillage.
Right, and the board is left to infer, and the board did review the material that was submitted, and to the extent it could extrapolate information from the information provided. It did so and was left with but one conclusion, which is that Mr. Yakah could not be recommended to this court for admission on motion or admission or permission to sit for the bar
Do you know
examination.
what other states are doing in this regard?
It's my understanding that less than half of the states in the United States allow for the admission of foreign students without obtaining further studies from an ABA-approved law school.
Does that mean an LLM or does that mean a JD?
A JD, a full law degree from a JD program, from an accredited school.
Would Mr. Yakov have the option of applying again and supplying additional information on the course descriptions and trying to fill in the blanks for you?
Absolutely. Of course, he could always reapply and provide the information, and the board would then conduct a similar review of that information to make that determination. I would submit that, as this court is aware, the review here is de novo, and Mr. Yakah and his counsel have had opportunities to submit that information here, including in a supplemental appendix that was submitted to this court, and did not supply such information. Of course, as any person is free to reapply to the bar, Mr. Yakah could do that.
Could I just ask for background so I know? When the board decides that someone doesn't have enough in their background, does the board ever go through and say, you know, you've got a lot, but we think you need, you know, American constitutional law, the Uniform Commercial Code, and, you know, something else, and sort of basically say, you know, 1 year that includes these courses for grades and credit at an ABA-approved law school, and we'll allow you? Or do they just go get a full 3-year JD, even if it's going to be cumulative of much of what the person has?
The rules and the BBE's guidances do provide for such a situation where the BBE may instruct an applicant to go and supplement their existing education.
Have they ever done that?
It's my understanding that it is the instances are few and far between, and the reason being, as in this case, there's no information to determine whether, in fact, as the court referred to earlier, immovable property in the Ghana School of Law actually is what the board and the ABA consider to be real property in the sense of an ABA-approved JD program.
So someone who provides more complete, you know, complete course descriptions and whatnot, the board can make an assessment, all right, that subject is sufficiently covered, that subject is sufficiently covered, but we see a few gaps that we would like to see covered at an ABA law school in something less than a full 3-year JD.
That is correct.
Okay.
Would a catalog from a law school suffice for course description purposes?
For that one piece, a course description, I think that it would, depending on the content, again, without actually seeing what the catalog looks like. And the institution from which the catalog comes would dictate what's contained in that information. So it would sort of, each of these considerations are a case-by-case basis of necessity. And so an example of course catalog, depending on its content and the information that it does provide to the board, could be sufficient to establish to the board that the education
I mean, we see in this
is-
transcript he took constitutional law, but we don't know what that constitutional law entails, right?
That's right.
We took Ghana legal system. That's irrelevant here. Ditto for criminal law. What is the criminal law of Ghana? We don't know. I mean, suppose he takes a case that gets involved in, you know, tricky items like lesser includeds and motions for required findings and all that kind of stuff.
Well, he also took constitutional law, contracts, criminal law, mass criminal law, all at New England School of Law in his LLM.
That is true, and the board did consider his LLM education in considering the qualifications. However, only a handful of the traditional JD courses were completed in that one-year program, and as the ABA has chosen not to accredit the LLM programs in for this particular reason, in that the ABA has not found that an LLM is a substitution for a JD in this
Correct.
context.
That's understandable. Not a substitution, but it can, in fact, provide additional evidence of education in relevant areas when one has already been to 4 years of law school and had a lot of basic training in legal principles.
Correct. And on that point, the board does consider other factors in determining whether a foreign applicant is qualified. And those other factors include actual legal practice in the foreign jurisdiction or other American jurisdictions. Here, Ms. Yakah provided limited information about almost 3 years of practice in Ghana following his admission there. According to the information submitted, he practiced both civil and criminal law in Ghana, and he did provide some letters of recommendation of his fellow bar members. He did not, however, provide any information or any detailed information with respect to the areas of law within the larger construct of civil practice or criminal practice to allow the board to evaluate that practice. Furthermore, as my brother explained to the court, he has not been admitted in any U.S. jurisdiction, and he has not practiced in any U.S. jurisdiction. On the information submitted, Mr. Yakah emigrated to the United States in the year 2000. His last practice in Yakah would have been, in Ghana, would have been before his emigration in the year 2000. Therefore, at the time of his motion for admission, he would have had no legal practice, save, I believe,
Is there a bar exam in Ghana? Do we know that?
There are, my understanding, and again, this is based on the limited information that
In the
Mr.
record?
Yakah has provided in the record, is that there's two separate 2-year portions of the legal education, and then when all the second level, when the exams are passed, then a person would then be admitted onto the rolls of Ghana. I
Well,
don't know.
that sounds like if you pass your law school exams, you're admitted.
Again, I
But we don't know.
I don't know the details, and the board was not given enough information to make that determination either. In the practice experience is by way of comparison and contrast to this court's decision in the Yakah case, and that is the applicant there was admitted in 2 separate American jurisdictions, New York and Louisiana, unlike Mr. Yakah, who has not been admitted. By contrast, or by similarity, neither applicant had any actual practice experience in the United States, upon which the board could look to determine, well, in addition to the legal education provided in a foreign jurisdiction, we're confident that this applicant has had some exposure and the degree of exposure that this applicant has had in an actual American practice system.
But when someone answers the application that he practiced civil law in Ghana and doesn't tell us the nature of what that practice is, criminal law for the same thing, you can't really derive much from that, can you, in terms of what is this person's experience?
Again, the board was unable to do
Did
so.
he try murder cases over there? Did he defend rape cases? Did he close real estate transactions? Did he draw up estate plans? Did he appear in divorce court? What does it mean?
Right, and my brother made the point that the applicant is not aware of what specific information the board is looking for in order to determine this qualification. And the board would submit that the burden, as this court found in Yakah, is on the applicant to provide, to meet that standard. And whatever it is from that jurisdiction where he was trained and admitted, he believes is sufficient to establish what it is he knows and what experience he's had is what should be provided. These are all individual inquiries, and there is not a bright line rule as to what exactly the applicant should provide for that very reason, that every jurisdiction
Are you
has
opposed
different-
to him being allowed to sit for the bar exam?
Again, the standard for being able to sit for the bar exam is an education equivalent to that provided in the ABA-approved JD program, and he has not provided information to satisfy the board that he has that education. His peers sitting around him in that exam have either graduated from such a program or successfully established to the board that level of education and training is met. He has not provided the board with that information. So yes, the board would argue that he has also not qualified to sit for the exam at this
This
time.
question may be unfair to you because you were not counsel in that case. So if so, please say so. What would you say are the major differences between this case and the case we heard last month regarding the Board of Bar Examiners?
I am somewhat familiar with that case, and without getting too specific into the details, just some sort of glaring differences would be the degree of practice of the applicant, the admission in other jurisdictions. These are all individual considerations. And as in Wajia, it's not sufficient just to be admitted somewhere else. That's one consideration. It's the actual practice experience. And so I think that would be one sort of glaring difference here. Further, my understanding is the applicant that you're referring to did provide materials such as course descriptions, and I believe actually course descriptions, and attempted to make some comparison between the course descriptions provided and course descriptions at ABA-approved law schools. And in that instance, the board also found that there was not enough information in order to make that determination. I think here we have a case where even less information was provided to the board and left the board with no choice but to determine that it could not recommend the applicant.
Thank you.
Thank you.